This is the oral summary of the Supreme Court judgment in Shagang Shipping Company Limited and HNA Group Company Limited. This appeal concerns a claim by the appellant under a guarantee of a contract to charter a vessel, which was met with the defence that the contract was procured by bribery and that the guarantee was therefore unenforceable. The allegation of bribery was founded on evidence of confessions made by the individuals who had allegedly paid and received the bribe. The claimant in turn alleged that the confessions were obtained by torture and for that reason were inadmissible as evidence in legal proceedings. The judge concluded that the allegation of bribery had not been proved, and that in those circumstances he did not need to rule on the admissibility of the confession evidence, but found that torture could not be ruled out as a reason for the confessions. The Court of Appeal allowed an appeal from that decision and remitted the case for redetermination. They did so on the grounds that the judge failed to ask and answer the correct legal question as to what weight should be accorded to the confession evidence, and, in those circumstances, fell into legal error in failing to take all the appropriate matters into account and failing to exclude irrelevant matters in considering whether the alleged bribe was paid. Those irrelevant matters included the judge's finding that torture could not be ruled out as a reason for the confessions. The Court of Appeal decided that, as a matter of law, if an allegation that a statement was made as a result of torture has not been proved on the balance of probabilities, a court, when estimating the weight to be given to the statement as hearsay evidence in civil proceedings, must disregard the possibility the statement was obtained by torture, even if, on the evidence given at trial, the court considers this to be a serious possibility which it cannot rule out. The Supreme Court unanimously allows the appeal and restores the judgment in favour of the appellant. Lord Hamblin and Lord Legate give the judgment, with which all members of the court agree. In relation to the relevance of the judge's finding that torture could not be ruled out as a reason for the confessions, the judge did not need to, and did not, reach any conclusion that torture had or had not been proved. Even if the judge had reached a definite conclusion that torture had not been proved on a balance of probabilities, there would have been no inconsistency between such a conclusion and the finding that torture was a real possibility that affected the reliance that should be placed on the confessions. The facts that the court can take into account in assessing the weight to be given to hearsay evidence in civil proceedings are not limited to facts proved the civil standard of proof. While it is settled law that evidence proved on a balance of probabilities to have been obtained by torture is inadmissible, there is no rule that if an allegation that torture was used is not proved to that standard, a possibility that evidence was obtained by torture must be ignored when deciding the facts in issue. In relation to the other criticisms made of the judge's judgment, first, the judge took the confession evidence into account on the assumption without deciding that the evidence was admissible. Having done so, the judge considered it unnecessary to make a finding on the torture issues, because he was, in any event, satisfied there was no bribery. The approach taken was both legitimate and consistent with the way the case was put before him. Secondly, the judge did address the weight of the confession evidence in the facts relied upon in his conclusion on bribery. It cannot be said that his conclusion was unreasonable or unsustainable, and there were ample grounds to support it. Thirdly, although it would have been more satisfactory for the judge to have addressed the confession evidence in greater detail, it is clear that he did consider the confession evidence of all three individuals, and the failure to consider it systematically is not an error of law. In summary, no error of law was made which would justify setting aside the judgment and remitting the case for fresh determination.